Hi, I'm Gwendolyn Sterk of Sterk Family Law, and Amy Schellekens is with me today to talk about special needs guardianship.
Yes.
Hi, Amy. It's a hot topic. So, we've got a lot of questions recently because you concentrate in the area of parents who have children with special needs, and they just don't want to get that guardianship when that child turns the age of 18. Can you explain the importance of the guardianship process?
Sure. If you have a child with special needs, at the time they turn age 18, the law automatically assumes that that child can make their own decisions. That would include medical and educational decisions. So therefore, if you take your 18-year-old child to a doctor appointment, they get to decide whether they continue to take medications, for example, that you may think are extremely important for them.
Now, it's very interesting to me because it's 18 for purposes of guardianship, but in family law, you really pay child support until they graduate from high school, so that could be after the age of 18.
And actually, even interestingly, for educational purposes, they qualify for the extended program until age 21. But still, actually, they would then get to make their own decisions for the IEP meetings, for example.
Right, so they could decide that they no longer want to be in that special needs program, correct? And they could disenroll themselves from school at age 19 if they chose to do it.
That's right.
And in addition to that, once they turn 18, they can exclude you from doctor appointments.
That's right.
And then certainly under the Mental Health Act, they would have had decision-making from that perspective as well, correct?
That's correct. Basically, they're charged with anything that any normal adult would make at the age of 18, but a child with special needs may need some special help in making those decisions.
Now, until they reach the age of 18, they don't need a guardianship because really the parent is the guardian, correct?
Pursuant to our Constitution, then you have parental rights until they turn 18.
And then if a parent's not available, then you could get a guardianship of a minor prior to the age of 18.
That's correct. If you have parents who are not available to make decisions or quite frankly, are not making decisions that are best interest of the children, and you think you can get a guardianship for a minor child, you certainly can do so. But for special needs children, we usually see that the most critical time is age 18.
Now, some parents say, well, I agree that my child's had some special needs up to this point in time, but I'm not so sure I want to put them in the box that they need a guardianship going forward and that they're adjudicated a disabled adult. So they delay doing it, but that's not the only option in terms of a guardianship, correct?
That's correct. They could actually file to do a limited guardianship, giving their disabled child some leeway on what decisions they can make, but giving the parents some say in other decisions as well. So for example, maybe that child could make some decisions about medical, but maybe not so much in the educational world.
Sure, and also maybe they want to have a part-time job,
correct,
or their ability to drive, which is outside the scope of the guardianship as well.
Absolutely.
So there are certain things contained and certain things not contained within that guardianship.
Right.
Don't you think that parents struggle so much, though, that they really don't want to put that on their child, so to speak, and they are afraid of the label? Talk about that for a little bit.
Absolutely, but there doesn't really have to be a label assigned with a guardianship. I think you're looking at what's really going to be best for your child making decisions. I wouldn't be concerned about a label of my child has a guardianship or doesn't have a guardianship. We can always modify at a later date if your child gets to a developmental stage where they can make their own decisions. I think the most important thing is making sure during that critical time that those decisions are being made properly.
Right, and then so you could terminate the guardian.
Correct.
The child could even file a motion at a future point in time to have the guardianship terminated, or it could be limited in scope at a future time.
Correct.
I also think that it's important as the child goes out and starts making financial transactions, a guardianship could then provide some protection to the family in that instance as well.
Correct.
Can you explain that a little bit?
Well, essentially, if you do a guardian of the estate can actually oversee the financial well-being of that child or disabled adult as well. That way we don't have someone spending money on something that maybe isn't in their best interest, or maybe we need to save that money for future care of that person. The guardian of the estate can oversee that as well.
Got it. Now, is a guardianship necessary for a parent to be able to apply for Social Security disability for the child?
Not technically speaking, no. However, it does give them significant advantage in making that application because then the determination that the individual is disabled has already been made.
Very good. Well, if you're listening today and you're in that situation where either one, you already haven't done it, or two, you're getting up to the age of 18, you need to start looking at what your options are. You can contact our office for a free consultation. Amy can address those issues with you and try to help you move forward with that child that has had some special needs.
Thanks, Gwen.
All right, have a great day, everybody.